Imagine you're a judge facing an impossible choice. Rule one way, and the President of the United States will probably ignore you, exposing your court as powerless. Rule the other way, and everyone will think you caved to political pressure. Either way, you lose. This was the nightmare scenario facing Chief Justice John Marshall in 1803. But what he did next was nothing short of genius. He lost the battle, but won a war that would echo through American history for the next 2 centuries, and counting. This is the story of Marbury versus Maddison, the most important Supreme Court case you've probably never heard of. It's a tale of bitter political rivals, midnight appointments, and one of the most brilliant legal maneuvers ever pulled off. And by the end of it, the Supreme Court would claim a power that would reshape American democracy forever. Let's rewind to where it all began. Act 1. The bitter election. It's the year 1800, and America is young, just over 2 decades old. The country is deeply divided between 2 political camps. On one side, you have the Federalists, led by President John Adams. They believe in a strong federal government. On the other side, the Democratic Republicans, led by Thomas Jefferson, who want more power in the hands of states and individuals. The presidential election of 1800 is vicious. Adams and Jefferson, once friends and fellow revolutionaries, are now bitter rivals. The campaign is brutal. Newspapers call Adams a tyrant, Jefferson an atheist. It's nasty, personal, and divisive. When the dust settles, Jefferson wins. This is huge. It's the first time in American history that power peacefully transfers from one political party to another. Nobody knows if it will actually work. Can Adams and the Federalists really just hand over control? Well, they do, but they don't go quietly. Act 2. The Midnight Judges. It's March 2nd, 1801, just 2 days before Jefferson's inauguration. President Adams is in his final hours of power and he's scrambling. The Federalists have already lost the presidency and Congress. They're about to lose everything, but there's one branch of government Adams can still influence, the courts. Just before leaving office, Adams and the Federalist-controlled Congress create a bunch of new judgeships, and on March 2nd, Adams nominates nearly 60 Federalist loyalists to fill these positions. The Senate, still controlled by Federalists, rushes to confirm them. These last-minute appointees become known as the Midnight Judges because Adams is literally signing commission papers late into the night of his final days in office. One of these appointees is a Maryland businessman named William Marbury. He's been nominated to be a Justice of the Peace for Washington, D.C. Not a glamorous position, but it's a job and it's his. The Senate confirms Marbury. President Adams signs the commission. The paperwork is sealed with the official seal by the Secretary of State. Everything is done. Marbury's appointment is official, or is it? Here's the problem. The Secretary of State responsible for actually delivering these commissions is John Marshall, who's been appointed to the Supreme Court but is still wrapping up his duties. And in the chaos of the transition, Marshall doesn't deliver all the commissions before Jefferson takes office. When Thomas Jefferson is sworn in on March 4th, 1801, several commissions are still sitting on a desk, undelivered, and Jefferson is furious. He sees these midnight appointments as a blatant power grab. Adams trying to pack the courts with Federalists on his way out the door. So Jefferson makes a decision. He tells his new Secretary of State, James Maddison, not to deliver the remaining commissions. As far as Jefferson is concerned, if they weren't delivered under Adams, they're void. William Marbury doesn't get his job. Act 3. The lawsuit. Put yourself in Marbury's shoes. You were appointed. You were confirmed. The president signed your commission. Everything was legal and proper, and now the new administration is just refusing to give you the job that's rightfully yours. So Marbury does what you do. He sues. In December 1801, Marbury and several other jilted appointees file a lawsuit directly with the Supreme Court. They ask the court to issue a writ of mandamus, which is a fancy legal term for a court order commanding a government official to do something they're legally required to do. In this case, force James Maddison to hand over the commission. Now, here's where it gets interesting. Marbury bases his lawsuit on Section 13 of the Judiciary Act of 1789, which gives the Supreme Court the power to issue these kinds of writs in certain cases. The case lands on the desk of Chief Justice John Marshall. Remember him? He's the same John Marshall who was Secretary of State when this whole mess started. The same John Marshall who failed to deliver Marbury's commission in the first place. Talk about awkward. Act 4. Marshall's impossible choice. John Marshall is in an impossible position. Let's break down his options. Option 1. Rule in favour of Marbury and order Maddison to deliver the commission. Sounds fair, right? Marbury does have a legal right to his job, but here's the problem. What if Jefferson just ignores the order? And let's be real, he probably would. Jefferson and the Democratic Republicans despise these midnight appointments. If Jefferson ignores the Supreme Court, it would expose the court as powerless. The fledgling Supreme Court would be humiliated. Option 2. Rule against Marbury and say he has no right to the commission. This avoids confrontation with Jefferson, but it makes the court look weak and political, like they're bowing to pressure from the executive branch. It sets a terrible precedent. And honestly, it's probably wrong on the merits. Marbury does have a legal right to his commission. So what does Marshall do? He pulls off one of the most brilliant legal maneuvers in American history. He creates a third option. Act 5. The brilliant decision. On February 24, 1803, Chief Justice Marshall delivers the court's unanimous decision. He structures his opinion around 3 questions, and the answers tell an incredible story. Question 1. Does Marbury have a right to his commission? Marshall's answer: absolutely yes. Adams signed it. The Senate confirmed it. Marshall himself sealed it. The commission is valid. Marbury has a legal right to his job, and Maddison is wrong to withhold it. So far, Jefferson is probably getting nervous. Question 2. If Marbury has a right, do the laws provide a remedy? Marshall's answer: of course. He writes, the very essence of civil liberty certainly consists in the right of every individual to claim the protection of the laws. If there's a legal right, there must be a legal remedy. That's fundamental to justice. And the appropriate remedy? A writ of mandamus ordering Maddison to deliver the commission. Now Jefferson is sweating. It looks like Marshall is about to rule against him. Question 3. Can the Supreme Court issue this writ? Here comes the twist. Marshall's answer: no, and here's why. Section 13 of the Judiciary Act of 1789 says the Supreme Court can issue writs of mandamus in cases like this. But, and this is the key, Article 3 of the Constitution defines when the Supreme Court has original jurisdiction, meaning when cases can start at the Supreme Court instead of lower courts. And guess what? Mandamus cases aren't on that list. So here's the problem. Congress passed a law that conflicts with the Constitution. The law says the court can do something, but the Constitution says it can't. Which one wins? Marshall's answer: the Constitution, obviously. The Constitution is the supreme law of the land. When a regular law conflicts with the Constitution must prevail. And since judges take an oath to uphold the Constitution, they must have the power to recognize when laws violate it. Therefore, Section 13 of the Judiciary Act is unconstitutional. The court cannot use it. The court cannot issue the writ. Marbury loses. Jefferson gets exactly what he wanted. Marbury doesn't get his commission. But Marshall just claimed something far more significant: the power of judicial review, the authority of courts to strike down laws that violate the Constitution. Act 6. The masterstroke. Let's appreciate the genius of what Marshall just did. In the short term, Jefferson wins. Marbury doesn't get his job. The Democratic Republicans are happy. Marshall avoided a direct confrontation with the president that the court would have lost. But in the long term, Marshall and the Supreme Court won something far greater. He established that the Constitution is real, enforceable law, not just a list of nice ideas. Courts have the power to interpret what the Constitution means. Courts can strike down laws that violate the Constitution. The Supreme Court is a co-equal branch of government with real power. And here's the brilliant part: Jefferson couldn't even oppose it. Marshall used judicial review to rule against Marbury and in favour of Jefferson's position. How could Jefferson argue against a decision that gave him exactly what he wanted? Marshall sacrificed the battle to win the war. He gave up a minor case to claim a major power. It's a masterclass in strategic thinking. Act 7. Why this matters today. You might be thinking, okay, so the Supreme Court can strike down unconstitutional laws. That seems obvious. Why is this such a big deal? Here's the thing, it wasn't obvious at the time. Nowhere in the Constitution does it explicitly say that courts have this power. Marshall essentially created it through interpretation. And he made it stick. And this power, judicial review, is the foundation of virtually every major Supreme Court decision you've ever heard of. Brown versus Board of Education, which desegregated schools. That was the court declaring segregation laws unconstitutional, using the power from Marbury. Roe versus Wade and Dobbs versus Jackson, the abortion cases. Judicial review. Obergefell versus Hodges, which legalized same-sex marriage nationwide. Judicial review. Citizens United on campaign finance. Judicial review. Every single time the Supreme Court weighs in on your constitutional rights, free speech, due process, equal protection, religious liberty, they're exercising the authority that John Marshall claimed in Marbury versus Maddison. Without this case, the Supreme Court would just be a panel of lawyers offering opinions. With it, the court became a co-equal branch of government with the power to shape American life. Act 8. The unresolved question. Now, we've told the story of Marbury as a brilliant strategic move, and it was, but there's another side to this story that's worth exploring, especially because it's at the heart of debates about the Supreme Court today. Here's the uncomfortable question. Did John Marshall actually have the authority to claim this power in the first place? Let's think about this carefully. Marshall declared that the Supreme Court has the power of judicial review, the power to strike down laws as unconstitutional. But where in the Constitution does it actually say that? Go ahead, flip through Article 3 of the Constitution, which establishes the judicial branch. You'll find that it describes what kinds of cases federal courts can hear. It explains the Supreme Court's original and appellate jurisdiction. But nowhere, and I mean nowhere, does it explicitly say the Supreme Court has the power to declare laws unconstitutional. Marshall inferred this power. He reasoned his way to it. His logic went like this. The Constitution is supreme law. Judges take an oath to uphold the Constitution. When a law conflicts with the Constitution, judges must follow the Constitution. Therefore, judges must be able to determine when laws are unconstitutional. It's elegant reasoning. But here's the thing, it's still just reasoning. Marshall essentially said, this power must exist, and made it so. He claimed authority for the court that isn't explicitly written in the founding document. Some legal scholars argue this was overreach. They point out that the Constitution's drafters knew how to be explicit when they wanted to grant a power. They explicitly gave Congress the power to tax, to regulate commerce, to declare war. They explicitly gave the president the power to veto legislation, to command the military, to make treaties. If the framers wanted the court to have the power to strike down laws, why didn't they say so explicitly? And here's another angle. Who watches the watchers? Marshall's reasoning assumes that judges are the ultimate arbiters of what the Constitution means. But why should unelected judges, serving for life, have the final say over laws passed by elected representatives of the people? Think about what judicial review means in practice. Congress passes a law representing the will of millions of voters. The president signs it, representing another electoral mandate. And then 9 unelected judges can just erase it, strike it down, override the democratic process. Critics call this counter-majoritarian. It's the opposite of majority rule, and in a democracy that's a serious problem to grapple with. Thomas Jefferson, for one, was deeply troubled by this. He worried that judicial review would make the Constitution a mere thing of wax, shaped and reshaped by judges according to their own views. He argued that each branch should interpret the Constitution for itself within its own sphere. Congress for legislative matters, the President for executive matters, and the court only for judicial matters. But Marshall's vision won, and it's Marshall's court, not Jefferson's vision, that we've lived with for over 2 centuries. The modern controversy. Fast forward to today, and these tensions haven't gone away. In fact, they're more visible than ever. You've probably heard the phrases judicial activism and legislating from the bench. These are criticisms that the court is overstepping its bounds, making political decisions instead of just interpreting law. Whether you agree with that critique or not, it's rooted in this fundamental question. How much power should the Supreme Court have? Consider recent controversial decisions. When the court overturned Roe versus Wade in Dobbs versus Jackson, critics argued the court was imposing its political preferences on the nation. But when the court originally decided Roe in 1973, critics made the exact same argument from the opposite side. When the court ruled on Citizens United and campaign finance, or on gun rights in Heller, or on affirmative action, or on presidential powers, every major decision reignites this debate. Is the court faithfully interpreting the Constitution, or is it wielding power it shouldn't have? And here's where it gets really interesting. Both sides of these debates rely on the power Marshall claimed in Marbury. Progressives want the court to protect civil rights and civil liberties, using judicial review. Conservatives want the court to limit government overreach and protect constitutional freedoms, using judicial review. And everyone wants judicial review when it produces results they like. But when it doesn't, suddenly people start questioning whether the court has too much power. We've seen proposals to expand the court, pack it with additional justices, to change its ideological balance. We've seen calls to impose term limits on justices instead of lifetime appointments. We've seen debates about whether the court has become too political or lost its legitimacy. All of these modern controversies trace back to Marbury. Marshall gave the court enormous power, but he couldn't guarantee that power would always be used wisely, or that people would always agree with how it's used. The constitutional tension. Here's the fundamental tension we still live with. We need someone to decide what the Constitution means when there's disagreement. But whoever has that power has enormous influence over American life. Should it be the court? Some argue yes. Judges are trained in law, insulated from political pressure, and can take the long view beyond election cycles. They can protect minority rights against majority tyranny. But others argue that's precisely the problem. Unelected judges with lifetime tenure, accountable to no one, making decisions that affect hundreds of millions of people? That doesn't sound very democratic. Maybe each branch should interpret the Constitution for itself, as Jefferson argued? But then who resolves conflicts when branches disagree? Maybe the people should decide through the amendment process. But constitutional amendments require supermajorities and are incredibly difficult to pass. The Constitution has only been amended 27 times in over 230 years. The truth is, there's no perfect answer. Every alternative has problems, and that's what makes Marbury versus Maddison so fascinating and so controversial. Marshall didn't just decide a case, he claimed a power that remains contested to this day. He shaped the court into an institution that's simultaneously essential to our constitutional system and troubling to many democratic theorists. Was Marbury rightly decided? That's a question legal scholars still debate. The decision has been remarkably durable. No serious movement has ever succeeded in overturning the principle of judicial review. But durability doesn't necessarily mean correctness. Maybe Marshall was right that someone needs to enforce constitutional limits, and courts are the best option. Or maybe he claimed too much power for an unelected branch in a democratic system. The honest answer? Reasonable people disagree, and they've disagreed for over 200 years. Epilogue. The irony of history. Here's a final twist. After Marbury, the Supreme Court didn't strike down another federal law as unconstitutional for 54 years, not until the infamous Dred Scott decision in 1857. And that case, which ruled that black Americans couldn't be citizens and that Congress couldn't ban slavery in the territories, is now considered one of the worst decisions in Supreme Court history. So the second time the court used the power Marshall claimed in Marbury, it used it catastrophically, which raises another uncomfortable question. What if great power doesn't always lead to great wisdom? But it didn't matter. The precedent was set. Marshall had claimed the power, and it would only grow from there. William Marbury never got his job. He faded into history as a footnote, but his lawsuit became the case that changed everything. John Marshall served as Chief Justice for 34 years. He's remembered as one of the most influential figures in American legal history, not for what he built, but for the power he claimed with a single brilliant decision. And Thomas Jefferson? He got what he wanted in the moment, but lost in the long run. The Supreme Court, the branch he thought would be the weakest of the three, became a powerful check on presidential and congressional power, all because of a case about a minor appointment he refused to honor. Sometimes the smallest battles determine the biggest wars, and Marbury versus Maddison was the small battle that shaped American constitutional law for centuries to come.